Hi, this is injury attorney Anna Burr. Today's video will discuss discovery, which is a very common aspect of litigation. And litigation is the process of the initial filing of a complaint to start a lawsuit, moving up to an eventual jury trial. So discovery is one of the first phases that the case enters into once the preliminary filings have been completed. And so discovery is sort of what it sounds like. It's an opportunity for both sides, the plaintiffs and the defense side, to discover what evidence there is available and what evidence may be used by the other side at trial. Discovery is really important now in today's courts because we're not allowed to surprise each other like you could do in the past and like you see oftentimes in the movies. Instead, we have to notify opposing counsel of all of the evidence that we have, all of the witnesses that we have, everything that we may be using in favor of our case to present to a jury in trial. So discovery comes in two main forms. The first is written discovery and the second is depositions. So written discovery it's all paper. It's all written like it sounds like, but the first part of it is to send disclosures to the other side, and that's where we send everything that we already have. For the plaintiff side, that includes medical records, medical bills. It includes information about how the injury happened. If it's a car accident, then it would include the police report or property damage photos. It would also include a list of witnesses. Those witnesses are the plaintiff and the defendant, the parties to the case. Also, any of the doctors who have been treating the plaintiff for their injuries, and what we call lay witnesses. And lay witnesses are people who are in your life who would be able to testify to the impact that your injuries have had. And so this can be family, this can be friends, co-workers who've seen that you need accommodations at work, that you have increased difficulty doing your job. Any people who have witnessed the injury and the impact that it had would be a good lay witness for you in your case. And so those things we are automatically required by court rules to send over. We have to disclose that stuff. And the defense does the same thing. They will send insurance claim notes, they'll send property damage info that they have. All of that information is exchanged between the parties. Once that's done, then we send discovery requests. And so if there's additional information that we feel is out there, or we just want to make sure that we have everything, then we send written discovery requests. And those include interrogatories, which are direct questions asked to the parties. For the discovery requests or the interrogatories that we receive from the defense for the injured plaintiff, those are questions about past medical history, if there have been prior injuries to the same parts of the body, details about the accident itself, details about treatment, details about the non-economic damages, which is pain and suffering. Again, going back to, it's asking about the lifestyle changes. Are there hobbies that you can't participate in? Did you used to be an Olympic athlete and now you can't compete? Things like that fall into the category of non-economic damages. And those are things that are going to be requested in the interrogatories. Written discovery requests also include requests for still more paper. Please provide prior medical records if you haven't done so already. Please provide medical bills that may have been unintentionally omitted from the initial disclosures, all of that kind of stuff. For the requests that we send to the defense, it's all of the same kinds of things. If you've got somehow obtained medical records about my client, please send me those. If you have information about a doctor who provided some kind of report, if you requested a record review from a defense doctor, please provide that report. All of that kind of information so that we make sure we have everything. The second main piece of discovery generally are depositions, and I'll talk more about depositions in another video, but basically a deposition is an in-person, or now in the age of COVID, a virtual Zoom conversation where the opposing attorney will ask questions of the party directly. It's their opportunity to speak directly to you without an attorney as an intermediary, though your attorney will be there. We don't just send you on your way and wish you luck. Your attorney is there to represent you, to make sure that all the questions asked are appropriate, and to help guide you and ease your nerves through the process. So that in-person question and answer session can be anywhere from half an hour to an entire day. It just depends, and that's something that your attorney will be able to prepare you for, depending on the facts of your case, the complexity of your case, and who opposing counsel is. So written discovery and depositions are the big pieces of discovery, which is a piece that everybody has to go through as a part of the litigation process. If you have more questions about this, I'm happy to answer questions always. You can post them here, or feel free to give me a call if you feel like this applies to you. Thanks so much.